Hello, I'm Robert Emmett Hernan, head of BlueStack Productions Inc., the publisher of Irish Environment, an online magazine covering environmental matters on the island of Ireland. And I'm very happy today to be at Stormont Government Buildings with Steven Agnew, who's the member for the Assembly from the Green Party. Steven, you're very welcome.
Thank you very much.
Steven, when did you first be elected to the Assembly?
I was elected in May 2011, so I'm just past 2 years into my role, and just prior to that, in January 2011, I was elected the leader of the Green Party in Northern Ireland.
And when was the Green Party formed in Northern Ireland?
The first kind of members who stood as the Ecology Party, which later became the Green Party, and that was in 1981. As you can imagine, in the 1980s was probably a hard time to get a political party off the ground in Northern Ireland, which was focused particularly on the environment. The name probably didn't help them either. Being called the Green Party in a conflict, it's often described as orange and green. You know, we were a different type of green that it was hard to articulate to the electorate the difference, and that indeed can still be a problem at times, although not to the same extent. So. But the party continued through the 80s and 90s, trying to offer, I suppose, a different perspective. I mean, we'd be one of the few parties in Northern Ireland that wasn't born of the conflict. So, you know, even if you take our colleagues in the Alliance Party, who set themselves up as an anti-sectarian party, and I respect them for doing so, particularly, you know, during the 70s when it was a difficult thing to do. It was still a response to the conflict. So even though they weren't unionist or nationalist, it was still a conflict party of sorts, even if it was seeking to resolve the conflict. So in that sense, you know, we were fairly unique in being a party outside the conflict. We're also unique in having an internationalist identity. I mean, we have two nationalisms in Northern Ireland. We have British nationalism and Irish nationalism, and the Green Party is internationalist. You know, so we have as much contact with our colleagues in the Republic of Ireland as we do with our colleagues in Scotland, England and Wales, and indeed across Europe. So again, we offer a bit of a different perspective in a Northern Ireland context.
Stephen, I thought that one of the issues that's become quite contentious, especially in the last week when there was the bill before the Assembly, is the planning process in Northern Ireland. And I thought it would be very helpful for the audience to have you walk us through the legislative process as applied to that planning bill. And I wonder if you could first start with kind of the context, and that is the process of the planning bill and the three changes which have been quite significant in that bill.
Okay, I mean, I suppose just to first put the planning bill in context, I mean, for me and for the Green Party, planning is fundamental to everything we do, you know, whether it's the health of our people to, you know, impacts on the environment, climate change, everything. I think getting planning right, how we plan our towns, our cities and our rural areas is absolutely vital. So for me, planning, because it is by nature quite a technical issue, it doesn't maybe get the coverage that its importance deserves, you know, because if you're not into planning, you know, all the issues can seem very dry. In terms of the legislative process, then I suppose the first part of the process will be consultation. The department will go out to public consultation, usually a minimum of 6 weeks, on usually longer, on its proposals. And really, this planning bill was about just putting into place some of the 2011 Planning Act, which was due to come into place when we have our revised councils, our reformed councils. But there's a need that actually those issues have been agreed on. Let's streamline them, let's bring them in now, because we need to assist development in a time of sort of economic downturn.
See, if I can, just to put in context, the planning controls are now within the central government, Department of Environment, but the plan is to, when the new 11 councils are created, that they'll be transferred to them, except for some significant developments.
Yeah. The idea is to move towards more community-based planning, giving more power to local councils, but also, I suppose, more accountability. You would hope for local councils as well. So. So yeah, there was a sense that some of the provisions that in there were so sound and could be put in place now, and that's what this current planning bill was supposed to be about. The idea was that it would be, you know, be non-controversial and should be, you know, it's really about fast tracking what was already agreed. well and good. So that was put out to consultation by the department. After consultation, then the department will publish a bill and basically a piece of legislation outline what the new planning law will be, and that's I suppose the first stage. So then, in terms of the legislative process through the assembly, there's a number of stages. There's first stage, second stage, committee stage, consideration stage, further consideration stage, and final stage. First stage is literally the minister standing up and laying the bill before the assembly and moving the bill, to inform assembly members the bill is prepared. You can view it, it's public, and there's no debate or anything at that point.
And this is after the consultation with
That's
the public?
after the consultation. Okay. Department should have taken all views into consideration, published their bill based on the feedback they've received. The second stage then is what we would call kind of the principles stage. So we have a general debate on the principles of the bill. What our parties in favour of it broadly, maybe areas of concern, but without getting into real specific detail, without starting referring to clauses or sub-clauses or any of that, just generally we're for, we're against, we've concerns about, we like, we don't like, and a very generalised debate on the principles, and to see, and it can happen that at second stage the Assembly just goes, we don't want this bill, and votes it down. That's possible. Certainly didn't happen at this bill, with this bill. The next stage is then after second stage it refers to the committee, and the committee will scrutinise it line by line, and the committee can conduct I suppose another consultation, bringing in key stakeholders, inviting comments from the public.
What committee was this now?
The Environment Committee.
Environment Committee, okay.
So whichever committee scrutinises that department, in this case the Department of the Environment, so the Environment Committee. So they will do that, present evidence, get feedback, debate it themselves. The committee then, the stage after committee stage is consideration stage, and that's the first stage where amendments can come forward from either MLAs or from the committee, or indeed from the minister himself. Because he will follow the committee stage, and indeed with any legislation it evolves as it progresses. You might get new legal advice, you might hear arguments you haven't heard, political circumstances might change, and things come forward, and we'll come back to that. But so that the committee then has the opportunity as a committee to present amendments, but they have to be agreed by a majority and as much as possible by consensus. Really for committee amendments, and often if the committee's clearly, and I suppose if you take into account that our executive, our government, is made up of 5 parties, each of whom are likely to be represented in the committee. If the committee starts clearly agreeing to something, often what will happen is the minister will agree to put forward those amendments himself, or herself as the case may be, himself in this case. The advantage of the minister doing it rather than the committee is the minister will have a department of experts essentially with legal advice that the committee wouldn't have access to, though it does have access to some legal advice. So there is advantage of the department bringing things forward rather than the committee sets out the principle of what it wants to see changed, and then the minister can take it. So that's part of what happens at committee stage. And you start to get a real sense of, you've had the second stage debate and then some of the committee scrutiny. You start to get a sense of where the parties are coming from then. So usually that's quite an open process, quite a transparent process. And then we come back to the full assembly at consideration stage, and that's consideration of amendments. And we go through the bill literally clause by clause, voting on each clause. If there's an amendment to any clause, that automatically triggers a debate on the amendment, and to some extent on the clause. And you can, for example, you can put in a notice to oppose a whole clause, so that automatically triggers a debate on that clause. The Bill's Office will group amendments, so if there's clear themes on a bill, in the planning bill there There was a clear theme around appeals and legal redress, so that was one group. Was a big amendment around economic planning zones, which I'm sure we'll come back to. It was in a group on its own, and then there was a number of amendments around, I suppose, balancing economic and environmental, economic, social, and environmental needs. So they'll be grouped. You'll debate each group. You'll vote in the individual clauses and the individual amendments, and by the end of consideration stage, effectively what you'll have is an amended bill.
Okay.
The stage after that's further consideration stage, usually 2 weeks after the consideration stage, so it's quite a quick turnaround. In further consideration stage, there is the opportunity for more amendments, but there's restrictions around the amendments, so you can't put in an amendment that would undo something the Assembly's already agreed to. They're called wrecking amendments. You're not allowed wrecking amendments. And by and large, further consideration stages is kind of just tweaking what you have. Now, it's up to the discretion to some extent of the Speaker how far you can go. You can put in the amendments and chance your luck. But it's supposed to be about final tweaks.
Right. Okay.
And then after further consideration stage, again, usually quite quickly afterwards, you'll get final stage, which is almost a kind of mirror of second stage again. It's back to broadly, do you support this bill?
Okay.
And, there would be nothing contradictory about having supported a bill all the way through and then rejecting it at final stage. Because at second stage, you might think, well, I agree there needs to be new legislation and planning. I agree we need to make things more efficient and whatever, but then come to the conclusion by final stage, well, this bill doesn't do that, or at least doesn't do it in the way that we'd like to see it. So,
or doesn't do enough.
Exactly.
Okay.
Yeah. Ultimately at that stage you're making a judgment call. Is there more good or more bad in this bill? And if your sense is, the bill will do more harm than good, you put it down. Or if there's just something, even one element that's just so fundamentally unacceptable to you. The Assembly, obviously each individual party can vote, but it takes a majority to vote a bill down. So and then after final stage, we have what we call royal assent, and that's really just a formal process. It's sent to Her Majesty and it's signed off on. And before that has to happen before it officially becomes law.
Maybe we can go back now to the three contentious issues. One, adding economic consideration as a kind of explicit criteria for planning decisions, where before it was basically sustainable development, which many people consider economic and environmental. So it was adding that economic layer, right? And the second was the limit on the right of appeal to grounds of human rights or violations of EU law. Yeah. And then the economic zones, which are under the control of the First Minister and Deputy First Minister, which would take planning control, arguably, into their hands. Yeah. Now, when were all those introduced to the bill?
The making economic development a material consideration. That was introduced in the face of the bill, so that when the Minister published the bill at first stage, we all knew that was there.
Okay.
So that had come forward. It was certainly a surprise because when the department went out to consultation, essentially what we were told was this is the 2011 Act, just taking elements of it out that we think we can implement now. Mm-hmm. That was a new element, and the Minister would argue it makes no difference, and then you would argue, well, if it makes no difference, why is it there? Right. Those who were concerned about it said, no, it explicitly puts economic development as a material consideration in law, but currently they're in policy. And there was a query because it was given equal status in the bill to sustainable development, that it and somehow give economic consideration greater weight than other elements of sustainable development.
And Frank McDonald from the Irish Times, yes. Definition of sustainable development under the Fianna Fáil government, he says development that must be sustained. So there's that one interpretation.
Yes, and that's certainly a concern about how it's been interpreted and planning to date. The other element of the economics was there was that particular piece with economic development as a material consideration was Clause 2. Clause 6 then said the planning must weigh up economic advantage and disadvantage. And this is where a lot of people felt, and this was probably where the greater concerns lay, was that, hold on a minute, what does this do here? Because economics were always a factor, economic impact was always a factor. This economic advantage and disadvantage suggests that, well, if you're setting up a cafe and you want to change your use of a building to a cafe, and there's a cafe owner two doors down, he can say, but that's my economic disadvantage.
It is in the case, certainly, in the Republic of Ireland as well as here, is that while there's a lot of complaints about slowing down the development process, the planning process, it's often other developers objecting to another. So it's business interest against business interest.
Yes, and that's what that seemed to exacerbate. It seemed to exacerbate the problem of rival businesses objecting.
So this was in the first stage.
Yes, that was on the bill as published at first stage. But it wasn't part of the consultation.
That's what I was saying.
And that again is where, people will talk about knee-jerk reactions and whatever else. Well, if you don't give people a heads up and ask them their thoughts, and you bring this out of left field, then you're going to get more of a kickback.
The other two, the limited rights of appeal, when did that, and the
economic plan zones, they came in at consideration stage. So, and this is, I alluded to my comments before, that the committee stage and the consideration stage were fairly transparent. The committee would take evidence, and often a lot of the amendments would have been through the committee, debated in public by the committee members after maybe hearing feedback from stakeholders. These amendments were submitted on the Thursday deadline. Now, a lot of amendments are submitted in the Thursday deadline before the debate on the Monday. That's not uncommon. I had some of my own, so I have to be careful. But they'd never been discussed at committee. There was no warning. Nobody was expecting them. And in terms of the economic planning zones, it was an 8-page amendment. Wow. So we're not talking about insert 2 sentences or delete or minor amendments here. This is huge.
Somebody was thinking about that for a long time.
Yes, right. And this has been worked on, and it was seen as well, not just to a party like ourselves who are outside of the executive, but even from the minister's point of view, the minister had no awareness of this. So this was about taking powers away from the environment minister and giving powers to the first and deputy first minister, coming from the parties of the first and deputy first minister, DUP and Sinn Féin, with no consultation with anyone else. And this is where we talk about collective government or lack of collective government, and collective responsibility. This was very much two parties in it for themselves, with their own agenda, without agreement from other executive parties, but with the numbers to push this through. And the sense was, as well, and it was alluded to, that this was done in agreement with the Westminster government. We've the G8, we've an investment conference in the autumn, and the British government have very much had a hand in this. So this was seen as deal with the Secretary of State as part of an economic package for Northern Ireland. Well, here's what we want from you. And some would fear it's an agreement to ensure fracking goes ahead. I'm certainly concerned that will be one outworking. I'm not convinced it's fracking alone. I think it's fracking and a lot of other development, and it really, the statement's been used by the DUP and Sinn Féin. It's about making Northern Ireland open for business, and I've always said this about making Northern Ireland wide open for business. Wide open for business exploitation of our people and environment. It's light touch regulation. It's deregulation effectively. Essentially, the synopsis of what it will do, it will allow the first and deputy first minister to say this type of a development is allowed here, 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 and here, without any scrutiny. Without any regulation. Just we carte blanche.
And no criteria set forth as to whether
they will set that.
They will set the criteria.
Now, so it's a lot of power with the department for no responsibility for planning.
And on the fracking, we were talking about this before. Is that it's my understanding? I think we talked that the Crown Estate owns the rights to the fracking minerals, because they own all the minerals. So any revenue from fracking would go to the government, and any negative things would stay in Fermanagh?
Well, As they're underground, they're owned by the Crown, but I understand the legislation is if a company is given permission to drill and extract those minerals, they become the property of the company that does the extraction. They are then required to pay a 7% royalty to the Treasury, the UK Treasury, and then it's for Northern Ireland to seek its share of that 7%. But yes, you're absolutely right that any environmental consequences, damage, social or environment, indeed health and environmental damage caused by fracking will be borne solely by Northern Ireland. In terms of deregulation, in terms of licensing of petroleum extraction, the Department of Enterprise, Trade and Investment, I sit on the Committee for Enterprise, Trade and Investment, has what they call an open door policy. So effectively anyone who applies for a license to extract will get it as long as they can demonstrate ability to extract. So the license process is deregulated. It's effectively, if you can demonstrate you can, we will permit you to do so. The next part of the process is getting planning permission. And that was where, and I'd been saying to people in the anti-frack campaign, no point lobbying the Enterprise Minister. One, she's in favour of fracking, but two, her bit's done, she's given the licence. It's planning, it's the Environment Minister you need to move on to now. And now we've got to FMD step in, take the power off the Environment Minister and say we'll take care of this. So really the kind of hopes to prevent this, a big chunk of that's been taken in the hands of certainly in the First Minister who's pro fracking as his party. And I suppose to come back to the other area we didn't talk about yet is the legal challenge and the restriction and judicial review. The other side of that group of amendments which I talked about was my own amendment for third party rights of appeal to allow communities to appeal planning decisions. That was voted for by every party with the exception of the DUP, who unfortunately had the power to block it. So on the one hand you had the DUP and Sinn Féin reduce the scope for judicial review, both reduce the timeline in which you could launch a judicial review from 12 weeks to 6 weeks, and reduce the scope. So we mentioned before you can't breach human rights law or EU law, but grounds of unreasonableness, irrationality, etc. being taken out. So even if you can demonstrate bad process, you've no legal mechanism in which to challenge it. And whilst they've said that you can't breach EU rules, I believe that to be a breach of the Aarhus Convention itself, which states you should, the government shall, and important legislation language is very important, government shall remove barriers to access to justice and environmental concerns. I'm not quoting the wording exactly, but that's the gist of it. But the shall is important because it places a must duty on the governments, and they've done the opposite. Rather than remove barriers to access to justice on environmental grounds, they've put up new barriers and restricted access to justice. So I think that element of it is certainly challengeable in the courts, and I'd be very surprised if it's not challenged should the legislation progress to final stage in royal assent.
Thanks for talking with us, Steve.
No problem at all.
Cheers.